Hi, I'm Tom Moukawsher, Connecticut Superior Court Complex Litigation Judge. Let's talk today about lawsuits. Why do lawsuits take so long? Is it really a matter of being thorough, of the wheels of justice grinding slowly but inexorably toward the right result? I don't think so. After around 40 years in court, it seems to me that sometimes we're just spinning our wheels. Cases are longer than they need to be, and too often we can't understand why they come out the way they do. But since it's not nice to complain about something without offering a solution, here's a brief introduction to ideas to fix things. If you want to know the details about them, each of them, along with many other points, is a chapter in my book from Brandeis University Press, The Common Flaw, Needless Complexity in the Courts, and 50 Ways to Reduce It. Now, my first complaint is about complaints, the document you file to begin a lawsuit. We should be able to read a complaint and immediately understand why somebody filed it. Who wronged them? How? But today's complaints, especially in federal court, are an embarrassment. Overreactions to Supreme Court rulings have made them spoofs of legalese and burnt offerings of form over substance. Instead of being short, plain statements, the simplest of complaints goes on for dozens of pages. They include every possible claim, including claims the author knows haven't got a prayer. They include every possible fact, including entirely irrelevant ones, because the author thinks that longer complaints look stronger. The form of a complaint is often litigated over for years, blocking courts from getting to the heart of a claim and actually resolving it. Courts should resolve cases on their merits rather than their form whenever it's possible. Many times, fly-specking of complaints throw parties out of court only to have them start all over again, sometimes repeated. Increases in court jurisdictional challenges have turned problems with the merits of a case increasingly into questions of whether the court has the power to hear the case at all. For example, frivolous lawsuits by prisoners against guards are often dismissed because the wrong person has been named as defendant or some administrative process has been neglected. Some of them can just be filed again later. Courts should save countless hours by holding that when no wrong has been done, no adjustments can save a lawsuit. Let's say the prisoner thought his bed was uncomfortable. It's better and faster in the long run to say that the Constitution doesn't give him the right to a comfy bed than it is to say that he got the warden's status wrong. Yes, you can say both, but when you do, the case is gone forever, and the prisoner can't say that you refuse to hear their case. Now, the third point addresses what is usually the largest time waster in every case, the formulaic ritual we call discovery. This process is supposed to be about collecting evidence, but too often it's more like riding a mechanical bull for hours on some sweaty night in some seedy bar, monotonous, annoying, pointless. Dozens of written questions and document requests are exchanged by both sides in the simplest of cases. They usually are accompanied by blisteringly complex sets of definitions and painstaking repetition of the same request for information in every way open to the imagination. These requests are almost always responded to with an equally tangled labyrinth of objections, often asserting that the request is overly broad, unduly burdensome, vague, and not reasonably calculated to lead to the discovery of admissible evidence. Protracted negotiations follow. Motions are filed, objected to, replied about. Oral argument dates are negotiated between the parties in the court. The questions and the requests are then slogged through individually before an annoyed judge or a magistrate judge. Rulings might come months or even years later, and the process often simply repeats itself. Most of a lawsuit is actually taken up with this bull riding, but it just doesn't have to be. Some courts are using and should expand standard orders governing the exchange of evidence, as in federal cases, and in state cases where personal injury cases and family lawsuits have standard forms of discovery. But more important, judges should confer with lawyers at the beginning of a case and ask them what it is they want from their opponents. Copies and drafts of a contract, for instance, communications related to it, and the like. The judge then drafts an order requiring that these things be exchanged. Parties are simply less likely to pretend that they can't understand a judge's order. Judges can then add to and police their orders at short hearings conducted without written submissions and on short notice. I found that talking things through rather than overwriting usually exposes the key evidence in a case and how the parties should be allowed to get at it. Parties should be compelled to admit undisputed things and stop wasting time proving those undisputed things at trial. Trials should focus on the dispute, not the undisputed. Yet today, most of the time at most of the trials is actually spent proving things that aren't even in dispute. For instance, the content of most financial records isn't disputed. Rather than spending 10 or 20 minutes authenticating a tax return, the parties usually don't dispute that the return is the party's return, and it says what it says. So often we can dispense with the time and actually with the tax return too. It is stipulated that Mary Jones's 2023 tax return reported $200,000 in gross earnings. Her bank account had a balance of $410,000 in it on May 4, 2023. The questions become not about whether these are real documents and what they say. The question instead might sound like this. You reported $200,000 in your tax return, but your bank records show $400,000 in payroll deposits. You didn't report all your earnings on your return, did you? It was August 1, 2023. You approached the intersection of Church and Elm around 12 p.m. The road was straight and dry. There's a traffic light there. Did you see the traffic light as you approached? Focus trials on the dispute, not form over substance battles to prove the undisputed. Briefs should be brief. Lawyers don't like to hear this, but most briefs aren't brief. And a typical 40-page brief today has a couple of useful paragraphs. Sorry, it's true. They waste time on needless background information, stuffy, overlength recitation of rules that we already know, the recitation of irrelevant facts, the killings of flies with sledgehammers. The lack of an engaging embrace of the heart of an issue makes reading briefs today too often penitential. And judges do it too. Trial judges' decisions should start with and focus on who wins the lawsuit and why. Like lawyers' briefs, too much of many decisions focus on unnecessary detail about the case background, the tangential legal and factual rulings, and irrelevant non-binding rulings from other courts. All this is done at the expense of explaining at adequate length the key reason for the ruling. No wonder some judges' rulings take years to write. Appellate judges do it too. Appellate courts' main focus should be on stating and clarifying the legal rules that lower courts must follow. They must follow precedent, but when there is none, they should create some in their own words and in ways that we can understand. If the rules have been followed and the lower court hasn't abused its discretion about the facts, the job is done. Courts must stop giving busy work to law clerks. If you've ever read a court opinion and marveled at the level of detail about what was filed when, what each party claimed at every stage of the lawsuit, along with the rulings of the courts of Luxembourg, it's law clerks writing this stuff. Not only does all this stuff detract and often entirely supplant an adequate explanation of a court ruling, it wastes the opportunity to have law clerks do something really useful, helping courts recognize and refine the rules of law, and then express them in ways that lower courts can use and even litigants can understand. The lawyer's billable hour should die. Billable hour is an incentive for needlessly long complaints, briefs, discovery, the whole lot. The billable hour puts lawyers' interests in conflict with their clients. Many firms today are experimenting with more sensible systems involving minimum lump sum payments, reflecting the value of what might be lost or won, win bonuses, and the like. If lawyers solve this problem, they might get more business rather than finding clients desperate to stay out of court in any way they possibly can. Well, that's the summary anyway. Each of these points is controversial. We can talk about all of them at great length. I detail the problems and the pros and cons of my solutions in my book, The Common Flaw. If you're curious, take a look. For the moment, thanks for listening.